Good afternoon. I want to welcome everyone to the Dallas Association of Young Lawyers February CLE. This is approved for 1 hour of CLE credit, and Sherry Harris, the DAYL's Executive Director, will put the course number in the chat. So please look out for it and self-report. Thank you for joining us. For those of you that do not know me, I am Blake Gladstein. I'm an associate in the litigation section of Munch Hart, and I have the privilege today of introducing Professor Misty Birdsong, a legal writing guru. Professor Birdsong is a clinical professor of legal research, writing, and advocacy, and she's the director of academic success at SMU Dedman School of Law. Professor Birdsong holds a Bachelor's of Arts in Philosophy from Baylor University and graduated summa cum laude and valedictorian from SMU Dedman School of Law. After law school, she clerked for the Honorable Robert E. Keaton, United States District Judge for the District of Massachusetts. She then came back to Dallas to join the litigation and appellate section at Baker Botts. After acing law school and the practice of law, Professor Birdsong decided to return to her alma mater to bestow her knowledge onto and help guide future lawyers. I was lucky enough to be one of those future lawyers. She has a way of making legal writing simple and making her students great writers. Today, Professor Birdsong will provide us with easy methods to be clear and concise in our everyday writing. And we have the Q&A function available, so please feel free to ask questions as she goes along and as you have them, and we'll do our best to address them at the end of the CLE. Without further ado, I will pass the microphone to Professor Birdsong.
Well, thank you, Blake, and what a kind introduction. I know there are a few former students on this webinar today, and those of you that have had me as a professor know there is nothing I love more than teaching young lawyers how to be good writers. I am passionate about it. I'm excited that you're all joining us. And I really do hope to give you hyper practical tips that you can use this afternoon after you leave our CLE to start improving your writing. So a little bit before we get going, I know we've said that we've called this, who says you can't teach young lawyers new writing tricks? But please know, these are not some brand new writing tricks that you've never heard. Some of these are probably going to be reminders, but that's important because what I've noticed with young lawyers is that you learn a little bit about writing in law school, and then you go off into practice, you start writing, and it becomes a little bit of a whack-a-mole game. You have many things to do. You're juggling a lot. And some of the fundamentals of writing and writing well start to fall by the wayside because we're not focused on that skill. We're just doing it, again, part of that whack-a-mole game. And so what I want to do today is remind you of some of those fundamentals, but then give you, again, some nitty-gritty, helpful hints that you can use immediately. Again, former students, you know, there is nothing I like more than giving you something hyper practical. So we're not going to be in the theoretical, we're going to get down to the nitty-gritty. So a little bit of background before we jump in. I am known for telling young lawyers that one of their biggest jobs is to save other people time. That does not sound particularly sexy. That does not sound particularly exciting. But I promise you, if you as a young lawyer are saving people time, whether that's fellow attorneys, senior lawyers who are assigning things to you, judges, clients, if you're the one who saves them time, you are the one that gets the more interesting work. You are the one that gets to advance more quickly. And so one key job, again, is to save other people time. There are other jobs that you have, of course. But if you can learn to save other people time, the story I tell is of a senior lawyer, an attorney at a firm here in Dallas, I won't name, who likes to say that if he has an associate who saves him time by the work they do, and that means that he gets to go to his son's baseball game, that associate is now his new favorite associate. And on the flip side, he's had associates who have cost him time through their writing and through other, we'll say through other practices. And that meant he couldn't go to his son's baseball game, and he no longer assigned good work to that associate. And so, again, there are other jobs we have as young lawyers, but I want you to think about this one and saving other people time, not just those who are assigning you work, but across the board as a lawyer. How can we save people time? And one of the best ways you can save people time is by learning to write well, not just accurately, but well. So today we are, as Blake mentioned, going to talk about how to be clear and how to be concise with these themes. Clear is kind and concise is nice. Again, there are other reasons that we need to be clear and concise, but one of them is because it will save those around us a whole lot of time. It also, of course, will make us more effective advocates. It will make us better colleagues. It will make us better members of the bar itself. But clear and concise writing is the key to saving people time. Now, especially as you're getting better at this skill, it does cost you time to really work on this skill of writing clearly and concisely. But the more you do it, the more not only do you improve in the skill, but it becomes a habit and therefore starts taking you less time the more you do it. So we want to get in the habit of writing clearly and concisely so we can develop the skill and so it becomes second nature. We don't have to think about it as much as the years go on. I want you to think about back to law school, those early days when you would get a really old case. Usually they're from the 1920s for some reason, and they're long and they're convoluted, and the paragraphs go on for 3 pages, and the sentences are also extremely long. And you would get assigned a case like that and just groan versus when you would get a more modern case that perhaps had headings and shorter paragraphs, and it was just clearer and more concise. And of course, we all know the answer to which one took more time to read, right? The 1920s case took a lot more time to read and frustrated you a lot more because it was not clear and it was not concise. So I often tell young lawyers, if you hated reading that in law school, then stop writing like that as a lawyer. You want to be the writing that saves other people time. So, one reason for today's session, yes, is to give you writing hints, but it's because if you guys are the young dogs that we're teaching the tricks to, I do hear a lot of complaints from older dogs that the younger dogs don't write clearly or they don't know how to write concisely. And that is by far the biggest writing complaint that I hear from senior lawyers and from judges is that young lawyers do not know how to write concisely, or at least they're not writing concisely and they're not writing clearly. Now, in all fairness, I hear that from some young lawyers about older lawyers or judges. So I know that it can go both ways. But that just means as a profession, we need to get back to this focus of how do I write clearly and how do I write concisely. And everything I'm talking about today, that goes from something as small as an email and as big as a Supreme Court brief, right? These writing hints and writing clearly and concisely is important no matter what you're writing. This is not just for appellate lawyers that are writing large briefs. This is all the way down to your transactional lawyer and you mainly send short emails to clients or to colleagues or to senior lawyers. Everything you write needs to be clear and it needs to be concise. And that way we can avoid some of these complaints. Okay, so here's our plan for today. Again, hyper practical tips and tricks for being clear. We're going to have kind of 4 buckets that we think about for writing clearly, and then we'll do the same thing with 2 buckets for being concise. I know there's a lot of overlap between clarity and conciseness, but for our purposes, we really want to think of them somewhat separately and then see how they impact each other. Because sometimes we focus so much on conciseness, we forget to be clear, or we think we're clear, so we don't need to worry about being concise. And we really want to have some practical tips and tricks for both clarity and conciseness. Then we'll go through a few exercises, depending on how we're doing on time, and an example of a brief that does a lot of what we're talking about today and does it well, so that you can see how effective these techniques are if you use them regularly. Then, as promised, I've got a little cheat sheet for you. So a lot of the examples I go through today, some of the kind of common problems that I list, you don't need to screenshot, you don't need to take furious notes. You will get a cheat sheet at the end in the chat so that you've got it to hopefully reference. Because again, I don't want this session to be like law school, where you nod, you say that sounds good, and then you go off and play whack-a-mole and kind of forget all about it. I want you to have something that you can take with you, that you can have next to you as you write, that you can be referencing a lot, so that hopefully you can develop this habit of clear and concise writing. All right, so let's start with clear as kind. As I said, we've got 4 big buckets. Before we get to that, though, I want to talk about the phrase clear as kind, because it's used quite a lot in non-law related scenarios. And the first time I ever heard it used was from a family friend who was an ER doctor. And he was telling a story as he was a young doctor that he was trying to be kind, but in his kindness, he was descriptive without being clear, and that would harm his patients or their families. And the story he told was leaving a waiting room and telling a family members, I'm sorry, we did everything we could, but it didn't work. And he's no longer with us. And they had a glazed, confused look. And he learned that the kindest thing he could do was come out and say, I'm sorry, your family member, your loved one died, period. Doesn't sound kind to our ears in some ways, but that kind of clarity was the kindest thing that he could do. And the same thing goes for diagnoses. Many doctors have talked about. That's where clear as kind comes up, right? The body is complex. They're trying to explain a complex problem you have. And if you're not trained in medicine, you need them to explain it to you, not with all the complexity jumbled up, but in a very clear way so that you can understand it. Just like medicine is complex, the law has its own complexity. We're just used to it. We live in the complexity of the law. So, like a doctor living in the complexity of medicine, we don't always think about how important it is to take that complexity and make it clear and remove the confusion and make it as clear as humanly possible. You need to do all that, of course, without losing accuracy or without losing depth. And that is the kind of Goldilocks that you have to find, not too much, not too little, just right. But the more you work on these tips and tricks, the more you'll find ways that you can be clear and concise without losing accuracy and depth that we need in the law. Of course, remember that one of the reasons we're doing clear is because it's going to save people time. They're not going to have to sort through and figure out what we mean and spend time interpreting and going through the complexity themselves. If we make it clear, we've saved them the work that we did to take the complex and make it simple to understand. So here will be our 4 big themes. The importance of explaining anything from general to specific. And I want you to get in the habit of doing this when you are texting your significant other, right? General to specific will always be clearer to people, and it's counter to how we actually communicate. So it is a habit that we have to start. Small bites we'll talk about, a much simpler sentence structure, and visual aids. So I'm going to take each one of these and go through how we can take this idea and practically start doing it right now. So let's read this. We have the procedure. Now, former students, you don't get to ruin the punchline for us. The procedure is actually quite simple. First, arrange things into different groups depending on their makeup. Of course, a single group may be sufficient depending on how much there is to do. If you lack your own machinery, find a facility or you can rent the appropriate machinery, then review your groups. It's better to work with groups that are too small than too large. Although your group size may not seem important, complications arise from overly large groups. Moreover, a mistake can be expensive. Working with machinery should be self-explanatory, and we need not dwell on it here. At first, the whole procedure will seem complicated. Soon, however, this process will become just another facet of life. Now, this does not have difficult vocabulary. You understand every word in this paragraph, and it's not a particularly long paragraph, but it's not clear. The first step that we could do to make it clear is to add a punchline. And here's what I mean. Is this easier to understand if I started with, every adult should know how to do laundry? Now, ideally, if I really were editing this paragraph, yes, of course, I would make the remaining sentences clearer. What I want you to see is just one tweak, just adding a punchline at the beginning, a clear punchline that gives you the full context, makes even your unclear sentences clearer. So that is the first step to becoming a clearer writer, is always starting with a punchline every time, over and over, no matter what you're communicating. The analogy that I give for this is the movie Sixth Sense. It has been out for like 20 or 30 years, so I'm about to spoil it because you've had time to see it. If you don't want to hear what I'm about to say, just mute me until I'm done. In the movie Sixth Sense, when I first saw it, it had been out for a while, but I did not know it had a twist at the end. I had no idea. My husband, I was watching it with, on the other hand, had it completely ruined for him. So he knew, here's the spoiler, that Bruce Willis was actually dead the whole movie. I had not heard that punchline. I had no idea. When the twist ending happened, I gasped audibly. And my husband, who's normally a very kind person, just don't let this story confuse you. My husband looks at me and says, Are you an idiot? How did you not know? It was so obvious the whole time. And he went through and pointed out different things in the movie that should have jumped out at me. Well, no, I'm not an idiot, hopefully. But the reason it did not jump out at me is because I didn't have the punchline to begin with. And because he had the punchline, all of these details and these things that most viewers missed jumped out and seemed clear to him. So having the punchline of the movie made everything else in the movie a lot clearer. Again, it was not the intelligence of the viewer, or in our purposes for reading, the intelligence of the reader. It was who had the punchline. And so after you give the punchline, that's not the end of it. We still want to keep going from general to specific, giving more detail as you go. You do this funnel from general to specific on a macro scale and on a micro scale. Again, as I said, you can do it in a text to someone, and you can do it in a giant appellate brief. And I'll talk briefly about how we do it macro and how we do it micro when we're talking about the law. Overall, I want you to resist the urge we all have to build up. That's more traditional joke telling or storytelling, right? It was a dark and stormy night, and we give a little bit more detail, and we start in the weeds and the details, and we build up to the punchline, or we build up to the result. Instead, we need to give the punchline first, then go a little bit more specific, then a little bit more specific, and then funnel all the way down to our detail. Most of how people communicate, unfortunately, is a reverse funnel. They start with the most detailed information and then build up to some big conclusion. We need to get out of that habit and go general to specific, starting with the punchline. So back to basics. There is a reason that in law school, years ago, you were taught IRAC. And I'm probably bringing back bad memories for some of you. I've had lawyers say, oh, I forgot all about IRAC. That is not a good thing. You were supposed to keep doing that all the way through and all the way through practice. But again, what happens is you hit the whack-a-mole game and you're just trying to address what you can, and all of those kind of fundamental ideas have gone out of our brain. Some of you have developed it as enough of a habit that you've continued doing it, and that's great. But I want you to know the why. Why do we have you do IRAC? Why do good legal writers use IRAC, or CREAC is what a lot of you use? That's because in and of itself, that is a funnel from general to specific. You start with the punchline, your conclusion, or your prediction about what the court's going to do, or your position about what the court should do. Whatever it is, you start with the punchline. That's your C in CREAC. Then you give the big rule that covers everything you're about to talk about. Some of you know that as the Uber law, whatever you want to call it, that big rule, that's the most general. Then you go a little bit more specific and explain that big rule, right? That's when you're giving what I call the rules of the game. So maybe you're defining terms, you're saying who it does and does not apply it to, all of those rules. Then you get even more specific, perhaps, and sometimes you want to actually explain one or two of those cases in more detail. You're giving some case illustrations. You're giving some rule and action examples. So if rule explained are the rules of the game, case illustrations are games that have been played. And again, I want you to see that this fundamental way of writing is not because professors and some old lawyers just like to kind of give you a formula and hope you'll follow the rules. It's because it goes from general to specific, and that's the way to be clear about the law. So we have punchline, the big rule that covers everything. Then you explain that in a little more detail. Then you show how those rules have worked in specific cases, even more detailed. And then at the very end, right, you apply it to your client's situation. Again, this can be just a paragraph that you're trying to quickly explain one little thing, or this could be a giant brief. Whatever it is, you could do it 6 times that you're doing this same structure over and over again. That's not what's important. What's important is this idea of funneling everything you do from general to specific over and over. So CREAC or IRAC, those fundamentals that we forget about, is a macro funnel. But we also want to explain things from general to specific on a more micro scale. So when you're doing rule explained, when you're giving hopefully all those extra rules to your reader that helps them understand that big rule, when you're doing that, even those should go from more general to more specific. Again, you You give the standard for that rule, maybe the test that's used to determine if you meet the standard, and then a definition within the test, and then perhaps an exception. That's still going from general to specific just within the rules. Same thing, very important. And I am receiving lots of complaints about this from judges. I've heard over the years. Case illustrations are where people really have that urge to build up from detailed to the punchline that I just talked about. So people like to say, in Smith versus Jones, an employee did X, and then the employer responded with Y, and they build up, and then they say, as a result, the court held blank. So they build to the punchline, starting with the details of the case. Even your case illustrations need to go from general to specific. You need to start a case illustration with the punchline. Punchlines are not just for the beginning of what you're writing, it's even within something like a case illustration. That means you start with the holding. In Smith versus Jones, the court held blank because. Then you can add in the detail. So again, general to specific from a macro standpoint, when you're thinking of organizing a document that you're about to write, whether that's an email, whether that's a brief, whether that's some sort of memo or short, memo to file, even on a smaller scale. When you're thinking of what order should I put these rules in, think general to specific. It's always going to be clearer. What about how do I write about this specific case? Give the punchline first, think general to specific, even when you're just discussing one single case. So it might be, for example, that you've had a senior lawyer who says, I just want to know what this new case says. Right? You're essentially doing a mini case brief and you think, well, this is kind of dumb. I'll just explain the facts and then what happened and all that. If you want to be better and save people time, start with the punchline of the case and explain the case, not chronologically, not here are the facts and then here's what happened procedurally and moving on, but from general to specific, and it will be 1,000 times clearer. This is one of those concepts that you're going to have to apply in lots of different situations. I know a few former students of mine who used to put a little Post-it note on their laptop that said general to specific, which just meant anytime I'm confused how I need to email someone and I want to make sure it sounds right, I think, how do I say this from general to specific? So it is a principle that you can apply across the board in all sorts of different communicating and writing, but again, specific to when you're explaining the law. Macro is CREAC and IRAC, and then we can even do it in a micro scale with how we explain rules and how we talk about cases. All right, so that's our first bucket, general to specific. Our next one is giving your reader small bites. So if we talked about that laundry sentence, right? Just adding the laundry sentence and doing nothing else was an easy way to make that paragraph clearer. That's the first way to make your writing clearer, like that you can do 30 minutes from now. The other way is just to give smaller bites. So we've said the law is complex. Another way to say that is it's just difficult to swallow. And in that case, if you give your reader shorter paragraphs and shorter sentences, those are smaller bites that are easier to digest. Now, at this point, I'm not talking about removing words from your paragraphs or removing words for your sentences. We'll get to that when we talk about being concise. I'm literally talking about cutting sentences into or cutting paragraphs into. So let's start with paragraphs. Make sure that not only is your whole document leading off with a punchline, but each paragraph leads out with the punchline every time, the punchline for that paragraph. If some of this is back to beginning of law school, the punchline at the beginning of a paragraph is really back to like middle school writing, right? That's a topic sentence. But I know many people use topic sentences either one of two ways. They just have a placeholder that really doesn't say anything. They just know they're supposed to have something there. Or it's just the first thing they want to say, and it's not really the punchline that gives context. So that laundry example, again, you needed to start that paragraph with, every adult needs to know how to do laundry. That's your punchline topic sentence. Did it technically have a topic sentence before that? Yes, but it was not a punchline. So that's why instead of saying topic sentences, I now say start with the punchline. And then within each individual paragraph, you need to be going from general to specific, even within your paragraphs. Again, whether that's an email about a transaction that's going on, or whether that's an appellate brief or anything in between. Each paragraph needs to start with the punchline and go from general to specific. And you need, seriously, one main point for each paragraph. Again, 8th grade English, right? But lawyers are notorious for wanting to put a whole bunch of stuff together in one paragraph because we just don't like separating it. You will lose your reader. Divide it into two. Just like you'll lose your reader in long paragraphs, you'll lose your reader in long sentences. So every sentence should also make a single point and then connect it with transitions. If you have a sentence that says ABC, comma, but XYZ, period, just cut that in half. Give them a smaller bite that says ABC, period, but XYZ, period. So same words, we're not even to the point of taking words out yet, but just making one sentence and dividing it and giving it as two, again, gives those smaller bites that are easier to digest. Sometimes I tell students and lawyers to just look and see, do you have a sentence that's going to 3 lines? That needs to be cut in half. We'll get to cutting words out later, but start with just cutting the sentence in half. Again, if your sentence has but or and or however, that's an easy place to divide it and then make that the transition word that starts a second sentence instead of a transition word that connects two phrases in a long sentence. The most useful conjunctions, by the way, are but and and. I know many of you were taught not to start a sentence with the word and not to start a sentence with the word but. Those teachers were wrong. They were telling you that because they didn't want you to write something like, I like pizza, period, but not ice cream, period. But as long as the second sentence is a complete sentence, it is perfectly fine and in fact very effective and clear to start with but or and. Those are the clearest conjunctions and the clearest ways to open a sentence and show how it relates to the sentence right before. And again, easiest way, divide it in half, start the second half with a but or an and. You've already made it clearer without even getting to removing words. Now, some of you, especially some of you litigators, are thinking, oh, but I need sentence structure variation and length variation. Yes. And that's where sometimes a 2 to 5 word sentence is really punchy and really effective, and then followed by a longer sentence. Longer sentences should be rarer. And overall, just shoot for an average of 15 to 20. The law is complex. I get that. So if you figure, yes, this sentence, I can't figure out how to divide it, it's just long, great. Just make sure the sentences around that long sentence are short. So you're not throwing a whole bunch of long sentences one after another. And then again, just count sometimes and see, am I about 15 to 20? Are all of these actually getting closer to 40 and I need to start cutting them down? That's just, again, nitty gritty practical. Look at your sentence lengths. So we had general to specific, especially starting with that punchline. Starting every document with a punchline, starting every paragraph with a punchline, jumps your clarity quickly. The next thing to do, start dividing those long paragraphs and dividing those long sentences into 2. Just cut them in half. Or into 3 if you're really good, and give your reader smaller bites. I liken this to like it's a child learning to eat solid food and you're cutting the meat into really small pieces for them because it's easier for them to chew and digest. Same thing here. Shorter is always going to be clearer. Not only that, but especially on paragraphs and even on sentences, we all know as readers, even if it were technically clear in a long sentence, we kind of glaze over the end of a long sentence and we glaze over the end of a long paragraph, right? Not only is it clearer to divide paragraphs and divide sentences, but you're less likely to lose your reader because readers, we are all readers. We don't like reading super long paragraphs. We don't like reading super long sentences. So again, not only is it clearer, but it's also just more reader friendly overall. All right, so general to specific, smaller bites. Now we're into bucket 3, which is simplify your sentence structure. Those of you that were English majors and you love creative writing, this might be painful for you, but we're not going for beauty in a storytelling way. You can get to that maybe as you're telling your client's story in the facts section of a big brief, but if you're explaining something, and particularly if you're explaining the law, if you can give simple sentence structure, it will be clearer. Okay, so here's what I mean. This is as practical as it gets. Keep your subject, verb, and object together and keep them at the beginning of the sentence. If you do that over and over again with transition words at the beginning of that sentence, right? So transition word or phrase, subject, verb, object, then all the complicated stuff. If that is just your basic default structure, your writing will be clearer. Now, yes, you'll sometimes vary that. That's okay, but make this your default. transition words, subject, verb, object. Transition words, subject, verb, object. Always easier to understand. This is another example of a hyper micro general to specific if you do that. Subject, you essentially have punchline, subject, verb, object every time. What happens is lawyers are notorious for wanting to put the complicated stuff either between the subject and verb or between the verb and the object. And it's very unclear when you do that. Now, you as the writer might think it's clear because you wrote it. You know what you're trying to say. But I promise you, sometimes it's as simple as, the employee who blah, 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 insert some complicated stuff, and then the verb. Instead of either making that complicated stuff its own sentence, or the employee did X, and then give the complicated stuff at the end. So this is so hyper practical. If you have a sentence that you think is feeling wordy and stilted and you cannot figure out how to edit it and how to fix it, just think, did I use what I call the SVO approach? Did I do, transition word or two if I need it, subject, verb, object together at the beginning? Many times your problem with your wordy, convoluted sentence is that you were not using this structure. So again, default to this and then vary from it when you need to, but make this your default. If you do this structure and if you use this regularly, you're going to actually avoid some of the problems that I'll be talking about in a minute that automatically fix themselves if you do subject, verb, object. So again, if you can make this the habit, then some of these other negative habits won't even arise because they don't work if you're doing subject, verb, object. Okay. Other way to have very simple, clear sentences. Again, 8th grade English, there is a reason we don't like passive voice. Now, I was also a litigator and an appellate lawyer. I also know there are times that persuasively it makes more sense to use passive voice. If you are a criminal defense attorney, you do not want to say, and then the defendant stabbed so-and-so. You want to say the victim was stabbed. But I hear that more as an excuse because when I read actual briefs and memos and emails and all those things, the passive voice is not a persuasive choice. It's just kind of a habit, or it's just kind of lazy and lack of editing. The great news is if you do subject, verb, object together at the beginning of a sentence, you're going to avoid passive voice. So you're going to solve that problem. But here are times, and again, most of these examples are either from ones I've seen or ones other professors have seen. The holding was reached by the court. If you change it to subject, verb, object, of course, you get the court held blank. That's pretty obvious to all of us. This is said a lot. A complaint was filed by employee. Employee filed a complaint. Again, if you just do subject, verb, object, your passive voice is gone. Our conclusion is supported by the case law, a very common thing that lawyers say. Case law supports our conclusion, subject, verb, object. So what I want you to see is this very practical tip of just, it sounds like, isn't that going to be boring to read? No, clear will not be boring. Clear is kind. Subject, verb, object at the beginning. And then if you need to add the complicated stuff at the end, you're going to get rid of this passive voice. It's possible for the witness to testify. We hear that a lot, especially if you're either talking about the timing of a hearing or a hearsay exception you want to establish and that this witness is available as opposed to unavailable. Instead, just say the witness can testify, subject, verb, object, or the witness is available to testify. So again, what I want you to see is these are very easy passive voice to change to active. But if these writers had started with the default subject, verb, object, they never would have gotten into the passive problem to begin with. Okay, so bucket 1, general to specific, especially starting with that punchline, but we're going to do general to specific in everything, and we're going to do it macro and micro. Then, of course, we have dividing everything, shorter paragraphs, shorter sentences, not even talking about getting rid of words yet. Just cut it in half, give your reader smaller bites, cut that meat into smaller pieces, and then simple structure. Now, everybody's favorite, but it really is effective, visual aids. Visual aids really do make your writing clearer. It's not just that it makes it prettier, it actually makes it clearer, and it makes information easier for your reader to find, especially if they go back to look at it later. And again, these are good in everything from emails to briefs and in between. I do these notoriously, even within my emails, even that aren't law related. But especially legal related emails, headings and subheadings. A heading or two in an email can be very, very effective. just as effective as it is in briefs that we're more used to using them. But headings and subheadings. Bullets. Now, I'm not saying write an entire document of bullets, but bullets can be much clearer than a long convoluted list if you separate it out and make it into bullets. The next visual aid is numbering. If it is a list and it doesn't necessarily rise to the level of needing bullets, but you want to divide it up and make it easier and clearer for your reader to understand these pieces, number it. Very visual, very reader friendly, but also makes it clearer. And then, of course, everybody's favorite, but it does work, bold and italics, especially combined or just italics or just bold, to highlight some keywords. This is especially helpful if you are giving a long quotation, either from a case or from the record or from a contract or a document of some sort. It needs to be clear to your reader which part of this document, what language is most important and needs to be focused on. And just using that visual aid of bold and italics can be very helpful. So again, some of you use these periodically, but I think you just do it because everybody does it. I want you to always think, if you've got a long list, should I make this bullets or should I number this? If you have multiple paragraphs, even in an email, I should probably put a heading or subheading somewhere here. What do I need to use in bold and italics to draw their attention to? All of these things really do make it clearer. All right, so those are our 4 big buckets. And again, you'll get a cheat sheet with all of this, so don't worry about it. But it's general to specific, on macro and micro, and always start everything, including every paragraph, with a punchline. Then we have shorter bites or smaller bites, then simple sentence structure and visual aids. If you do these 4 things, if you start, even just take one little nugget from each of those 4 and start putting it into practice, your writing will immediately start to get clearer. Again, you're not going to be a perfect writer overnight. None of us is. I still work on my writing constantly. It is a skill we should constantly be honing. But just pick one thing from each of these buckets. Maybe you're just going to always start with the punchline, whether you're writing an email to someone, whatever it is, you're like, that's my new thing. I'm going to start with the punchline. I'm going to divide my paragraphs. I'm going to do the subject verb object thing, and I'm going to start doing more headings. If you just picked that nugget from each, I promise you, the others are working with you will notice, judges will notice, other lawyers will notice, and you'll just be, again, you'll be a more effective writer, but you'll also be a more effective advocate, you'll be a more effective employee, and you'll just be a better lawyer, not just a better writer. Okay, so that's clear as kind. Now we move on to concise as nice. My favorite thing, the former students that are here know that the #1 comment you're going to get from me is make this more concise, make this more concise. And many, of course, say, how do I do that? And so over the years, I and some other professors have noted the most common wordy stuff we see and the most common problems we see with people not being concise. And again, we had 4 buckets for clarity. We're going to have 2 for conciseness. The first one is shorten your phrases and your words. And I'm going to give you lots of examples of the problem phrases and the problem words that lawyers use that we're going to shorten. And again, on your cheat sheet, you will have this list. So you can literally check something you've written and see if you used any of the problem phrases or words. And I will give you what to use instead, as practical as we can get. Not only shortening phrases and words, but then, of course, getting rid of redundancy. And those are the 2 big problems lawyers have. They have words they don't need, and they have redundancy. Okay, and as you note on here, and I talked about at the beginning, there is some overlap, right? The clearer I get, the more concise my wording will hopefully be. The more concise I am, the clearer my writing, right? There is some overlap, but I do want you to think of them somewhat separately. Noting, of course, like we just looked at active and passive being clear. The active sentences were always more concise than the passive. They were also clearer. So there will be some overlap, but I do want you to be working on both of these skills throughout your career. Okay. The first way, and this is the hill I will die on, the first way to get rid of words you do not need is avoiding nominalizations. You did not know you were coming to a grammar class today, but a nominalization, to remind you, is a verb or an adjective that functions as a noun. These are some common endings for nominalizations. It'll be on your cheat sheet. So again, if you can't figure out whether you should get rid of something, see if one of the words has this ending. Here are some examples. Saying gave a report instead of reported. Now notice these won't all have the endings. That's just a little, again, a cheat sheet, a hint if you're having trouble. And then we have made a decision. That's that ION ending. Instead, you should say decided. The court made a decision that. You should just say the court decided. These, again, are so common with lawyers. So I've really tried to keep this focused on what I see in lawyers writing. Offered a suggestion. Again, that ION ending, you just mean suggested. Resulted in an increase, increased. Led to the destruction of, another ION, destroyed. Entered into a settlement, very common. You just want to say settled. And I know for some of us, we think, oh, but that's how everybody says it. Great, you are now going to be the clearer writer. You're going to be the clearer lawyer, and hopefully we'll continue to shift this pendulum so that everyone in the law starts getting rid of these common nominalizations. Made a statement, stated. Now, every time I say this, when someone's like, well, but what if it's that you're trying to say that the witness gave a statement to the police? Okay, yes, there are times that it might be okay to use these nominalizations, but you have to make sure that you are intentionally choosing it, or it's a legal term of art, and not that it's just your default way to describe it. Acted on an assumption, assumed. So if you get rid of nominalizations, you're going to have a domino effect. It's going to make the sentence clearer. It's also going to be in a more active voice, and it's going to be more concise. So you get 3 birds with 1 stone if you fix your nominalizations. Again, if we go back to subject verb object approach, if you use that approach, it will help you avoid nominalizations. If you're having trouble identifying a nominalization, use subject verb object, and it will hopefully start to get rid of that naturally without you having to do a second step or a second way through editing. So here's some examples of it in a sentence. The court provided analysis on the issue and offered its conclusion the defendant was guilty. Again, some of these come from actual documents. If you went subject verb object, you would naturally get rid of the nominalization. The court analyzed the issue and concluded defendant was guilty. Same thing, the usage of the property by defendants was for the storage, I hate this one, of stolen jewelry and murder weapons. You just want to do subject verb object. The defendant stored the jewelry and murder weapons on the property. Notice subject verb object, more detailed stuff on the property. An agreement was made by the parties to reach a plea deal by Monday. Instead, let's change it to subject verb object, get rid of the nominalization. The parties agreed to reach a plea deal by Monday. I love this one. There was an affirmative decision for expansion by the administration. Subject verb object, the administration decided to expand the program. This you'll actually see a lot, and I hope that I alert you to these, you notice these, and then they start to bother you. The majority opinion contains a discussion of legislative history. That discussion, that ION ending again, instead, the majority opinion, subject, discusses legislative history, subject verb object. So what I want you to see is that connection. Again, we talked about using that SVO approach fixes passive voice. It also will fix nominalizations. That's one of the reasons I'm so big on teaching lawyers that just do subject verb object at the beginning of the sentence and complicated stuff at the end. Okay, so those are nominalizations. There are some other common phrases. I won't read all of these. They will be on your cheat sheet. Some of you former students know I despise the phrase prior to. You just mean before. I realize that is in almost everybody's professional bios, and if I could change them all, I would. But you can start a new approach and change prior to before. As a result of is very common. In the present case, people love to start that when they're jumping to application. In the present case, just say here, much clearer, much more concise, much more direct, much more effective. Again, you'll see pursuant to a lot with statutory sections, pursuant to section 1983. Just say under section 1983. It's simpler, it's clearer, it's more concise. If you start replacing these common phrases in the law with the short version, your writing will be so much more effective and you'll be a much more effective lawyer. I love in the event that, we hear that. In the event that, you just mean if, so just say if. In regards to is very, very common. We received your letter in regards to, you just mean regarding. So again, you'll get a list of all of these so you can have them next to you and make sure you're not using them. Then there are some idioms that we use a lot. The fact that she died caused him a lot of grief. You really mean her death caused him a lot of grief. This list you will also get, but I want you to notice how many the fact that's are here. And so one of my hints for you is to, after you finish writing something, just do a find and see how many the fact that's you have in different contexts. And that's going to be an idiom or a legal phrase that you can change. Because of the fact that is because. He was aware of the fact that is he knew. Notice how many the fact that's are in these idioms or in these phrases. In many cases, you will find that, as we say a lot, you just mean often. Situation in which the court, during the time that, and my favorite, for a period of 10 weeks. You just mean for 10 weeks. So just cut it down. All right, so again, you'll get a list of all of those because those are the ones I see the most, and hopefully you can then use that list and check your own work as you go. And then we have long words. So now I'm also funneling for you, right? We're going general to specific. Now how do we take long convoluted words themselves and make them shorter words? We've already talked about and, we've talked about but. Then we have things like utilize. People love the word utilize. They just mean use. So just use the word use. Don't utilize the word utilize. Again, you'll get a list of all of these, and but being the most effective, but also so and use. If you start shortening that, it will make it more concise. And because there's that overlap, it will make it clearer for your reader. And then we have everyone's favorite redundancies. And there are really two types of redundancies that we see in legal writing. The first is redundant legalisms, and then we have redundant modifiers. Now, both of these, there may be a reason to use them, but just be careful. Again, you'll get this in your cheat sheet with a list of all of these. Save and accept is my favorite. You just mean accept. Most of these, you don't need both words. Redundant modifiers are things like free gift or personal opinion that you really don't need the modifier. You just need to say it's the expert's opinion, not it's the expert's personal opinion. Final outcome. If it's the outcome, it's final. Basic fundamentals, all of these sorts of things. Again, sometimes either the legalism or the modifier. The legalism, it might be a term of art, it might be required. You just have to use it. It's just what the court says, so you got to do it. Maybe with the redundant modifier, you're doing it for a persuasive reason. You're saying final outcome because you're really trying to emphasize the finality. But what I want you to be on the lookout for is when are you just doing it out of habit? And when are you actually needing to use it because it's a term of art, or doing it for a persuasive reason for emphasis? And even then, if you're doing it for emphasis, there are also often other ways you can emphasize other than redundancy, but at least you have a reason for the redundancy. All right, so pulling that together before we get to just a couple exercises, and I want to leave some time for questions. So we had clear as kind and concise as nice. Our 4 buckets for clear as kind: go from general to specific, give smaller bites, cut everything into smaller bites, shorter paragraphs, shorter sentences, give that subject, verb, object, very simple sentence structure, also avoiding passive voice, and give your reader some visual aids. Those 4 things will make things clearer. And then concise is nice. Get rid of your nominalizations, shorten all those common phrases and idioms and everything that we use in the law just to 1 or 2 words, and get rid of redundancies. Okay. I'm not sure we'll have time. I was going to have you guys actually do this, but what I want you to see is it's easy for me to talk in the abstract. It's much harder when it's your own writing or when you're trying to edit something that someone else has written. So here are some examples of what we've talked about. This is not an excessively long sentence, but it's wordy and convoluted. The arbitrator shall deal only with the matter which occasioned her appointment and shall cease to exist on the final decision of that matter. Very unclear. So if I'm counseling a young lawyer, I would say, first step, divide this into 2 sentences. And by doing that, you're going to force yourself to write it more clearly. Here's where it would be in 2 sentences. The arbitrator shall deal only with the matter for which she was appointed. Her appointment ends when she issues a final decision. And notice again, subject, verb, object, complicated stuff at the end. Her appointment ends, subject, verb, object, when she issues a final decision. Okay, love this one. We are in receipt of your letter requesting our representation with reference to the obtaining of your permanent resident status. This is why people hate lawyers, because some write like this. Please note that with regard to our previous discussions with you during our telephone and office conversations, we do not usually handle cases of this nature. So if I were telling a young lawyer how to change this communication to a client, I would say, thank you for your letter requesting we represent you in obtaining permanent resident status. And then again, clear as kind and start with the punchline. Unfortunately, we cannot represent you. That is clear, and that is the punchline. Then you can say, as we explained in our previous conversations, we do not handle immigration cases. Much clearer. Much, again, leading with that punchline. Let's move on. Okay, we'll skip over this one because it's pretty easy, but we have the reason for, instead of just the reason for the dispute is that neighbors were unable to come to an agreement. Instead, the neighbors disagreed about why the clothesline collapsed. And here's an example of putting it actually into one sentence, but numbering it. It's a visual aid example. You can just say, this brief is weak because, and then number the 3 reasons, and it will make it much clearer. Especially if you have a long sentence, you're not sure you can divide, add the numbering, and that kind of provides a little bit of division, a little bit of smaller bites to begin with. Okay, I'm going to, let's see where we are on time. I'm going to take a question, and then if we have time after that, I'm going to stop sharing because I have another brief to show you if we have time after that. So do we have one question, it looks like?
Yes, Professor. We have one question.
All right.
And the question is, are legal writing classes available for attorneys to register and practice their legal writing? And so it's a 2-part question. Would you recommend any virtual writing training course?
I would love to create one at some point because I'm so passionate about this. You know, I know there are some firms that have brought in legal writing, either professors or experts that come and train their younger lawyers. They're relatively few what you're talking about, but I think there's about to be a push to start having a little bit more of that, especially now that we're kind of coming out of COVID and all of that. There already was a move to that. COVID kind of interrupted it because everyone was playing a little whack-a-mole on their real jobs. But law schools in general are looking at some more online programs to provide to lawyers, either to get certificates in other arenas, and legal writing is one of those arenas that they're starting to talk about. There are some good resources, and your cheat sheet, I actually, because I use some written resources that are online, your cheat sheet references a few of those if you can look at them there also. But I just think anytime you can do a CLE on writing, again, because then it forces you to step out of the whack-a-mole game and really think about the skill of writing, which we don't do a whole lot, but great question. Do I see another one?
We do. We have any advice for applying these great tips to contractual drafting and editing?
Yes. Oh, this is such a passion for me. Because, and again, I'm a litigator, but I did work with our transactional group a fair amount because of the type of litigation I did. This idea of general to specific actually really can help in contract drafting, and starting with the punchline. Getting rid of redundancies, if you can convince the older lawyers to do it. Some of them are very attached, but some of those redundancies that I listed are actually most common in contracts. And so if you can just have a list of redundancies like that next to you, again, save and accept, full and complete, all those sorts of ideas, you can start. They're really not necessary, most of them, but we tend to want to write it the same way the person before us wrote it, or use some forms that others have used. So redundancies are the best for contract drafting, starting with the punchline. Especially in each section of a contract, starting with the punchline can be really helpful to make it easier. And even this idea of bulleting, visual aids, I think we need to use more in contract drafting. Bulleting, numbering, headings, all that kind of stuff. The more you can do that in contract drafting, the better and clearer it is. Now, there are times you don't necessarily want it to be clear, and I understand that. And there are times when the agreement is touchy enough that if you make it clear, the other side may decide they don't want to sign it with it that way, but you got to walk that line. But yeah, redundancies, visual aids, starting with the punchline, general specific, all of that works with contract drafting too. Do we have one
For
more?
those of you that
Okay.
need it or that want it, sorry, not that need it, well, that want it, the DAYL handout, the cheat sheet, should be in the chat for everyone. If you did not receive it or you could not download it from the chat, I believe that Sherry Harris will email it to everyone who RSVP'd. So
Yes.
who to attend this CLE.
And it looks like maybe we have a third one.
That was the third one. It was about.
Oh, that was the third one. Perfect. Okay. I think we're kind of out of time. Any other final questions? Oh, go ahead. Go ahead, Blake.
Before everyone leaves, I want to give you, Professor Birdsong, a huge thank you. Thank you for spending your time and sharing some amazing insights with us. I really appreciate it. I think all of the attendees really appreciate it. These insights were pure gold. I know that I learned so much, and I was reminded so much of the class that I had with you in law school. And now I'm going to go back and look at my case illustrations and a brief that I'm writing and make sure that I'm writing them from general to specific and not using any passive voice. So appreciate that. I also want to thank the whole DAYL CLE Planning Committee and the DAYL Executive Director, Sherry Harris. Again, without the committee and Sherry, these CLEs could not exist. So thank you guys very much. And lastly, I want to thank all the attendees for such a great turnout and for sharing your time with us. Again, today's presentation was approved for 1 hour of CLE credit, and Sherry Harris put the course number in the chat. So jot it down and self-report. With that said, Professor Birdsong, any closing words? But for me, have a great afternoon for everyone.
Same with me. Have a great afternoon and start writing clearly and concisely.
Okay, thank you guys. Bye, everyone.